This is Bloomberg Law with June Grasso from Bloomberg Radio.
The music industry faced off against internet providers at the Supreme Court this week over a $1 billion jury verdict against Cox Communications for not shutting down the accounts of customers who'd pirated more than 10,000 copyrighted songs by artists like Beyoncé and Justin Timberlake. The lawyers painted very different, bleak pictures of the consequences of a decision against their clients. Joshua Rosenkrantz represents the internet provider Cox, and Paul Clement represents the record companies.
There is no surefire way for an ISP to avoid liability, and the only way it can is to cut off the internet, not just for the accused infringer, but for anyone else who happens to use the same connection. That could be entire towns, universities, or hospitals.
If Cox is right on the law, then Cox could take tens of thousands of copyright notices and throw them in the trash, and they could have its employees say F the DMCA.
The issue is whether internet providers should be held responsible for contributing to copyright infringement when they know their customers are pirating music but don't terminate their internet access. Several justices appeared skeptical that Cox had done enough to stop piracy and questioned whether a favorable ruling would allow internet service providers to ignore clear copyright infringement by their users. Here are Justices Sonia Sotomayor and Amy Coney Barrett.
You did nothing. And in fact, Counselor, your client's sort of laissez-faire attitude towards the respondents is probably what got the jury upset.
What incentive would you have to do anything if you won? If you win and mere knowledge isn't enough, why would you bother to send out any notices in the future?
But Justice Samuel Alito expressed concerns about the effect on large institutions like universities or hospitals if an internet service provider is forced to cut off infringers.
What is an ISP supposed to do with a university account that has, let's say, 70,000 users? What is the university supposed to do?
My guest is intellectual property litigator Terence Ross, a partner at Katten Muchin Rosenman. Terry, will you explain the issue here and the process of policing music piracy?
The issue in the case involves process by which recording companies track online sharing of musical compositions that they own the copyright in. The process allows them to identify the IP address and the ISP that is providing the service to that IP address. And so the music companies, the recording companies regularly, on a daily basis, in fact, send notices of infringement to the ISPs that are providing the internet service to these infringers. And there are days in which they're sending out 10,000 notices to each individual ISP service. And the recording companies finally became fed up that the ISPs were not doing something. They wanted the ISPs to cut off service to these identified infringers. And the ISPs dragged their heels on doing anything, taking any real concrete action to stop it. And so the recording companies finally sued Cox Cable Company, which is one of the largest ISPs in the nation, alleging that they had engaged in contributory copyright infringement.
In its papers, Cox had argued that Grandma will be thrown off the internet because Junior visited and illegally downloaded songs. Did some of the justices seem to pick up on that concern?
There was only one justice who seemed to give some credence to that, and that was Justice Alito. He was the only justice who really seemed to buy into the position by Cox that it was hesitant to kick people off because of, and then you can fill in the blank as to what the reason is. They're a grandmother, they're a university, they're a hospital. In fact, the hypothetical he posed at oral argument in the Supreme Court was what happens when all you can do is identify that the IP address belongs to a university. Are you going to shut down the entire university? One of those odd hypotheticals that takes the case to the extreme. The facts are actually contra to that. And indeed, none of the other justices seemed to buy into that argument. The reality is that over the period of time in issue, Cox had received 163,000 notices of infringement and had kicked off of its service only 32 customers. The policy of compliance used by Cox was described in some detail, and it was somewhat laissez-faire, to use the word that one of the justices used to describe it. They had originally started off and say, well, if we get 3 notices about a particular user, we're going to tell them we're cutting off their service. That rose gradually over time from being a 3 strikes you're out policy to being a 13 strikes and you're out policy. And the 13 strikes reset every 6 months. So if you didn't get to 13 within a 6-month period, you went back to 0. Or if you got kicked off after 6 months off, you got put back on. They also capped the number of notices that they were accepting from recording companies at 300 a day. And then probably the worst fact of all, and which got brought up at the Supreme Court, if you could believe it, was the head of copyright compliance at Cox sent out an email to the people in charge of enforcing copyright policy in which he said, F the DMCA. Now, the DMCA refers to the Digital Millennium Copyright Act, which is one of the key statutes at issue here, and which requires ISPs to set up a policing mechanism against copyright infringement if they want to claim the safe harbor that is embedded in the Digital Millennium Copyright Act. In response to that, one of the minions for the head of compliance wrote back saying, well, we're helping law-breaking customers. And there were dozens of emails like this amongst the compliance group at Cox that just manifested a complete disdain for copyright laws, which obviously impacted the jury because the jury below had awarded $1 billion in damages against Cox. And in the Supreme Court argument, it was clear that outside of Justice Alito, none of the 8 other justices were buying what Cox was trying to claim was their reason for not cutting off people, that you'd kick grandmas off of the internet. The other 8 justices just didn't buy it, and it was a loser argument for Cox.
So then can you tell where most of the justices do stand?
That's always a tough question. In this case, I think it's tougher than most. I think outside of Justice Alito, the other 8 were just incredibly skeptical of Cox's excuses for allowing this widespread infringement to go on. In the record below, there's apparently one period of time at which 21% of all traffic on the Cox internet connection, 21% involved copyright infringement. And the lawsuit below didn't go after, every single mom and pop business or every single college student. It was targeted only at distributors, not people who were downloading the occasional song, but people who were copying music digitally and distributing it on a mass scale. So there was this enormous skepticism expressed by the justice, except for Justice Alito, that Cox really wasn't fulfilling its obligation and needed to do something differently. Now, on the other hand, there also seemed to be some concern about the size of the jury verdict and whether or not the actions of Cox were sufficient to constitute willful contributory infringement, which is what set them up for much larger scale of damages than if this had been found to be just ordinary copyright infringement.
So what's the standard that the justices would use here? Cox contends that under a 2005 Supreme Court ruling, it can't be held liable for contributory infringement unless it affirmatively fostered piracy or clearly intended to promote it. The music companies say it's enough that Cox new subscribers were using its service to download songs illegally.
The case on appeal to the Supreme Court presented 2 pretty crisp issues for decision. The first issue, which I think is where the real fight is going to be, is whether or not contributory copyright infringement required some sort of affirmative action by the defendant. The second question presented for review was whether or not willfulness required some sort of knowledge of customer infringement. Now, the problem with that second question, the willfulness standard, is that Cox had failed to object in the trial court to the instruction that the judge gave to the jury about how to find willfulness. So after the case is finished, all the evidence is submitted, and the attorneys have made their closing argument, and just before the jury goes into the jury room to make a decision, the judge reads to them a series of instructions as to what the law is. And one of those instructions will go something like, Sony Music Corporation here has alleged that the contributory copyright infringement was willful on the part of Cox. In order for you to find willfulness, you must consider the following factors. And typically, if a party doesn't believe the judge has stated the law correctly to the jury, they get up and they object. And indeed, they don't even have to do it at the time of trial. These jury instructions are sent out to the lawyers well in advance, and you file an objection with the court saying, we object to this, and give the court a chance to refine it, improve it, so that there's no objection. Here, the Cox folks, for whatever reason, failed to object to the willfulness instruction. And that means they waived any objection to willfulness and had really no excuse. So I just don't see question number 2 as being resolved in any way in favor of Cox. And indeed, I suspect the court won't reach it, so that we will get no further instruction from the Supreme Court on what constitutes willfulness. I think the court is focused really on the position that Cox is arguing that contributory infringement requires some sort of affirmative act, and that, as they phrased it, they can't be a contributory infringer by providing internet service to one of their customers.
So then, do you think that they'll send it back to the lower court with an instruction?
I just don't know what they're going to do here. I have to be frank. This is one of the more opaque oral arguments I've listened to. Other commentators have argued that the court might be looking for some sort of middle ground. Indeed, I think it was Justice Sotomayor commented at one point during the argument that the court was being forced to choose between two extreme positions. And in particular, Justice Sotomayor, who was very skeptical of Cox's position, but also didn't quite like the extreme argument being made by Sony Music Corp and the recording company, seemed really perplexed as to what to do, genuinely perplexed. The problem the Supreme Court faces here is that the standard for contributory copyright infringement has been pretty well settled in this court for more than a century. As early as 1912, there was a case that involved mimeograph machines. If you remember those, they were pre-Xerox machines way of doing sort of a mass production being, a couple hundred. And there was a case in which a publisher sued a mimeograph company for knowingly selling mimeograph materials to a company that it knew was engaged in infringing copyrighted works by using the mimeograph machine. And the standard was set out there and has been repeated over and over since that time, 1912. And the standard is pretty simple. If you provide something that you know is going to be used by a person to commit copyright infringement, you've engaged in contributory infringement. And the past cases haven't spoken in terms of needing an affirmative act. Although one could argue, this did not come up at the Supreme Court hearing, that providing the internet service is an affirmative act. The Cox Company argued in the Supreme Court that that's not an affirmative act, but that's sort of a stretch. In order to try to get around that line of cases, the Cox Company argued that contributory infringement is really akin to aiding and abetting liability in the context of torts and criminal law. And that's a real stretch that I think is just dead wrong. It would give the court a way to get out of this dilemma, but it would mean the court would have to overturn half a dozen cases going back to 1912 for over a century and say, now they're not good law anymore. I don't see the court doing that here.
Do you think we'll see the justices coming up with some sort of middle ground?
So it's a shame that Justice Ginsburg is no longer on the court. And we've had many conversations about her knowledge of copyright law and her ability to cobble together coalitions for positions under the Copyright Act that are actually quite pragmatic and useful. And I just don't see anybody either with that depth of knowledge of copyright law or the ability to do that sort of log rolling on this court. And so I think it's going to be a real struggle for this court to come up with some sort of middle ground, particularly in light of the fact that the law here is just so set for such a long period of time, and the sort of odd cases that Cox cited to the Supreme Court, including this recent gun distribution case the Supreme Court decided recently, where the gun companies were being sued for deaths in Mexico. And the argument was they were aiding and abetting this criminal activity. And the gun company said, well, we sold the guns to dealers in Texas, not knowing what they were going to do with them. And if anybody's contributed to them, but it's not us. We had no knowledge of it. And that case just doesn't fit here, either legally or factually. And yet Cox sort of bet a lot on that. I mean, it was almost as if they're saying, oh, hey, we cite to some case in which, the Second Circuit, which everybody believes in on the Supreme Court, that'll get us over the hump. It's just such a stretch that it, in fact, backfires. One starts to think, well, what's wrong with their case that that's the best they've got?
Yeah, gun distribution and pirated music don't seem to equate. Thanks so much, Terry, as always. That's Terence Ross of Katten Muchin Rosenman. Immigration courts decide about 200,000 asylum applications every year. And Douglas Urias-Uralana, his wife and child, joined that pool of applicants after fleeing El Salvador in 2021. They claim they were repeatedly threatened by a cartel hitman in a years-long violent vendetta against their extended family. But an immigration judge rejected their bid for asylum, as did the Board of Immigration Appeals, and a federal appeals court deferred to the board's decision. And it appeared during oral arguments this week that the family would not fare much better at the Supreme Court. Several justices from across the ideological spectrum appeared to agree that the board's decision on whether an immigrant faces persecution serious enough to qualify for asylum is a factual inquiry, not a legal one. And so the Court of Appeals should defer to the Immigration Board's decision. Here are Liberal Justice Elena Kagan and Conservative Justice Samuel Alito.
And that's the legal rule. A threat can be persecution, but only if it's menacing enough to cause actual harm. Now, what's going to happen in this case is we're going to have to look at all this evidence, all these facts, and decide whether these threats were indeed that level of menacing. And that sounds like really weighing evidence to me. That sounds really factual.
It must add up to more than ordinary harassment, mistreatment, or suffering. You may have a set of historical facts that are undisputed, but determining whether they add up, whether the totality of those facts satisfies that standard, sure looks to me like primarily a factual question.
Joining me is immigration law expert Leon Fresco, a partner at Holland Knight. Leon, tell us a little about the asylum process.
When a person asks for asylum, they have to prove at the end of the day that they have what's called a well-founded fear of future persecution on the basis of their race, religion, political origin, social group. There's a presumption that if you have experienced what's called past persecution, there's a presumption that you will then have a well-founded fear of future persecution. So what does that mean? That means that people go into immigration court and they explain what happened in their country that caused them to leave. And there's cross-examination and the judge can ask questions. At the end of all of this, there's two determinations. One, did the person experience past persecution? And number two, was it on the basis of one of the protected grounds? So in this Supreme Court case, what happened was there literally was no dispute about the credibility of the facts raised by the foreign national, in this case, Douglas Humberto Urias-Orellana, who said that he fled El Salvador after repeated threats and violence from a hitman linked to a drug lord. And he said that the drug lord shot his half-brothers and tracked and threatened his family. And so, since there was no dispute about the facts, there was not a factual issue that was being raised on appeal. Instead, the court said, I'm going to take all of the facts that you've presented today as true, and I'm going to say that they still do not rise to the high level of this word persecution such that we can say that you experienced past persecution such that you would get the presumption of future persecution. So now Mr. Urias Orellana then says, well, how is that possible? I would like to get review of that. And so when it gets to the First Circuit Court of Appeals, the First Circuit says we're going to defer to the Board of Immigration Appeals, which is the administrative court that decides this issue at the end of the day. We're going to defer to them and say that even though the facts are not in dispute, we still have to give some deference to their decision in terms of, let's say there's a scale and you're weighing it. How many pebbles go on one scale? How many pebbles go on the other scale? That even that determination gets some deference, that the federal courts can't just reweigh the evidence on their end and decide whether the facts that were undisputed in a particular case constituted persecution such that the person should win their asylum case.
And the circuit courts of appeals have been split on whether federal courts can review the immigration board's decision from scratch or have to defer to the board.
The Supreme Court then has to decide, okay, what happens in a case like this where there's not a dispute about the actual facts, but there's a dispute about whether the facts, when you weigh them, there's quote-unquote significant enough pebbles on the scale. Does the foreign national win or do they lose? Can we reweigh that on our own, or do we have to give some deference under some standard of deferential review? And so the foreign nationals obviously claiming there should be de novo review. The court should look at this and say, okay, were the threats here that were undisputed sufficient to say that that was past persecution? And the government says, no, the standard is actually much different, and that this is a mixed question of law and fact, and so you have to treat that with some type of deferential review. And so you had justices like Justice Gorsuch saying a reasonable fact finder standard as opposed to de novo review, and others wanted to weigh it even more deferentially, potentially, than even that, and say that basically if there's substantial evidence to support the determination of the lower administrative court, that's enough. So that would be even a broader deferential standard. And it appears as if really there's not a lot of excitement in the Supreme Court for having a complete de novo review of this process. So the issue is really going to be how much deference is given in these types of cases moving forward.
So, Leon, just to clarify, everyone accepts that the facts of the asylum claim are determined by the court below, the immigration court. So the only question is how the federal appellate court is going to weigh those facts?
Correct. So what the lower court said in this case was, yes, all these very bad and serious things happened to you, but when we put all those pebbles on the scale, they're not sufficiently weighty enough to actually constitute persecution for the purposes of winning your case. And then the question is, okay, when this gets to the federal court, can they literally reweigh all of that exact evidence and say, no, those stones do weigh enough to tip the scales in favor of the foreign national? Or are they stuck with, hey, if this is in any way defensible, we have to keep this decision the way it is? And it seemed like the Supreme Court did want to give more deference than rather reweighing all of the facts in the case, even if they're undisputed, to decide if they meet the legal standard of past persecution.
If the appeals court can't reweigh what the lower court decided, it's not much of a review, is it?
Correct. I mean, it would only be a review if essentially what happened was somebody goes into immigration court and they say, the government came in and shot me one time in the left arm because I'm a dissident, and then they left. And then 2 weeks later, they shot me in the right arm. And then 3 weeks later, they shot me in the left leg. And they said, do you want this to keep going, or are you going to stop being a dissident? And then the immigration judge says, well, that doesn't seem like sufficient persecution. You only got shot 3 times. Maybe in a case like that, then the court would say, well, there's no way a reasonable fact finder could come to that determination that that wasn't persecution. Because then you'd have this sort of reasonable fact finder deference or some other standard like that. It's not never will we review it. So they're not saying never, but as opposed to a case like this where they're saying, okay, threats, how serious are the threats? Were the threats very serious? They might say, look, this is the kind of case that falls in the gray zone. And when you're in the gray zone, the government wins.
I'm curious, what do you think about the threats in this case? Do you think they were serious enough for an asylum claim?
I think it's really in the gray zone. I think this is the problem when they talk about sort of bad facts make bad law, is this is the exact type of case where one judge would definitely grant asylum 100 out of 100 times, and another judge would never grant asylum 0 out of 100 times, because people just approach these cases with different levels of sympathy and different levels of concern and different standards in their mind of what constitutes persecution. It really does become problematic in terms of the subjectiveness of the process. But what the Supreme Court's trying to figure out is, where does the subjectiveness stop? Does it stop at the Court of Appeals, or does it stop at the administrative level? And it seems like they're going to stop it at the administrative level for the most part and not bring in sort of a new antiseptic Court of Appeals who's just reading a transcript without any other context and deciding, is this sufficient persecution? It didn't really seem like any of the Supreme Court justices wanted to do that de novo.
I agree. In these arguments, it seemed like the justices were mostly on the same page. Thanks as always, Leon. That's Leon Fresco of Holland Knight. And in other Supreme Court news, on Thursday, in a 6-3 decision, the court came to the rescue of Texas Republicans, allowing next year's elections to be held under their newly drawn congressional map, despite a lower court ruling that the map likely discriminates on the basis of race. Joining me is Bloomberg Supreme Court reporter Greg Stohr. Greg, what was the reasoning of the 6 conservatives for allowing Texas to use this map?
Well, the court gave us a little bit of its reasoning, a little bit less than 2 pages of it. First of all, they said that the district court that ruled against Texas, that said these districts are probably a racial gerrymander, that lower court did not, quote, honor the presumption of legislative good faith. In other words, it should have given Texas the benefit of the doubt that it was acting constitutionally. Secondly, the Supreme Court said that normally in cases where you're challenging a racial gerrymander, you have to produce an alternative map that would accomplish whatever the state's trying to accomplish without using race so much, and they faulted the challengers for not doing that. And then finally, the court said this decision came too close to the election. In the past, the Supreme Court has said that federal courts should not change the state's election rules on the eve of the election. And you might say, well, the election's not for another 11 months or so. But in this case, Texas's filing deadlines were coming up, and the Supreme Court said that's close enough and that's a problem. So the federal court shouldn't act, even if it found the districts, as it did, to be probably unconstitutional.
All 3 liberals dissented. No surprise there. What was the focus of Justice Kagan's 17-page dissent?
She mostly focused on the process that this district court went through to gather evidence about what was going on, why the state drew this map, and in particular looking at things like this letter from the Justice Department that said that the state should eliminate these so-called coalition districts that are made up of heavily Hispanic, heavily Black voters, with the 2 of them combining to be more than 50% of the district. And Kagan said the Supreme Court should have deferred to those factual findings of the district court, who spent 9 days hearing evidence about this case, and she blasted them for essentially deciding this thing over a holiday weekend.
And then on Friday, the justices announced that they'll take up President Trump's planned rollback of automatic birthright citizenship. Are you surprised that they took this case, since it's basically universally been accepted that the 14th Amendment confers citizenship on virtually everyone born on U.S. soil?
Not at all surprised, because this is the kind of thing that the Supreme Court wants to do itself and not leave to the lower courts. So lower courts have, across the board, ruled against Trump on this and said that what he's trying to do through his executive order is unconstitutional and also in violation of federal immigration law. But given that these are decisions that block the federal government from doing something, that's almost always something the Supreme Court wants to do itself.
A lot of big decisions that are going to be coming out of the Supreme Court this term. Thanks, Greg. That's Bloomberg Supreme Court reporter Greg Stohr.
What I saw in that room was one of the most troubling things I've seen in my time in public service. You have two individuals in clear distress, without any means of locomotion, with a destroyed vessel, who were killed by the United States.
Congressman Jim Hines, the top Democrat on the House Intelligence Committee, described his reaction to video footage of the second attack that killed two survivors after an initial strike on an alleged drug smuggling boat in international waters near Venezuela on September 2nd. Lawmakers and military legal experts have questioned whether the attack on survivors was a war crime because international law prohibits killing enemy combatants who no longer pose a threat. Navy Admiral Frank Bradley, who oversaw the strikes, briefed lawmakers on Thursday in closed-door sessions and confirmed that there had not been a kill-them-all order as reported. After the briefing, Republican Senator Tom Cotton, chairman of the Senate Intelligence Committee, said he believes the men did still pose a threat after the first strike.
I saw two survivors trying to flip a boat loaded with drugs bound for the United States back over so they could stay in the fight.
Joining me is Professor Joshua Kastenberg of the University of New Mexico Law School. He was a military judge and lawyer in the U.S. Air Force. Josh, Democratic Senator Chris Van Hollen said the second strike was an extrajudicial killing amounting to murder or a war crime. What's your analysis of the second strike?
So my take on the second strike is partly colored by the fact that the administration has this changing narrative constantly. And the latest narrative that they come up with is implausible, that somehow these men were going to climb back on the vessel and continue on in their cocaine run. So having said that, look, the United States has convened grand juries for murder on the high seas going back to the War of 1812. And there's a federal statute prohibiting precisely what occurred, murder on the high seas. Now, of course, Trump himself is immune from any criminal liability thanks to the Supreme Court's decision, Trump versus United States. But it seems to me that nobody else is immune from that kind of a charge. On the other hand, who's going to pursue it? I don't think the Attorney General of the United States is going to differ from the White House's version of events or their own legal reasoning.
Defense Secretary Pete Hegseth said he left the room after the first strike. Who's responsible? The Navy admiral who ordered the second strike? Or the defense secretary who reportedly approved the overall operation?
Well, they all are. And I'm chuckling in a sad kind of way about that claim of Secretary of Defense or Secretary of War Hegseth's, because at the end of the day, it really doesn't matter in this regard. Coming out of World War I, if not the Civil War, the United States embraced the doctrine of command responsibility, and we particularly saw that play out in World War II at the Nuremberg and International Tribunal for War Crimes in Tokyo, those trials. And even in U.S. law, when the Army under General MacArthur prosecuted General Yamashita, nobody ever alleged that he was the trigger puller or gave an order for his troops to massacre thousands of innocent Filipinos as the United States liberated the island. They prosecuted him for failing to control his troops and for creating the environment where it would be made possible. The only thing in a real rule of law setting that would save Hegseth is if he preferred UCMJ charges against the individual who gave the order. But I don't think that's going to happen. I think they're all banking on protection from Republican allies in the House and Senate, and then ultimately presidential pardons, which have now been given to Honduran drug dealers.
What about the legality of the broader military campaign, which is ongoing? After the briefings on Thursday, the military announced that it had struck another boat, killing 4 people. That brings the death toll to at least 87 people.
So we are not at war with Venezuela. And the idea that United States domestic law can reach into Venezuelan waters has no basis. However, and this is a big caveat, under international maritime law, any nation can stop actions such as piracy or other high crimes that occur on the sea. In order to do that, you have to have absolute correct intelligence that a crime such as international drug trafficking is occurring. And there has to be some sort of agreement among nations that that is occurring. And on top of that, you have to be able to show that what you're doing is consistent proportionality-wise to the crime involved. And the problem with that proportionality aspect is that the United States Coast Guard, which most often does not use that kind of lethal force, does an excellent job of stopping kilo upon kilo upon kilo of cocaine coming into the United States. They don't catch it all. So, the argument that this is lawful is sort of stretching the realism of law into the Alice in Wonderland of law.
Let's turn now to the video released last month by 6 Democratic members of Congress, directly addressing active duty military and intelligence personnel.
Right now, the threats to our Constitution aren't just coming from abroad, but from right here at home.
Our laws are clear. You can refuse illegal orders.
You can refuse illegal orders.
You must refuse illegal orders.
No one has to carry out orders that violate the law or our Constitution.
We know this is hard and that it's a difficult time to be a public servant.
But whether you're serving in the CIA,
the Army,
or Navy,
the Air Force,
your vigilance is critical.
And know that we have your back.
All 6 who have military or intelligence backgrounds were just telling service members and intelligence officers what the law is. Yet President Trump has called them traitors and said they were engaging in seditious behavior punishable by death.
Well, first of all the members of the House and Senate who made that video said was you have a duty to obey the law, and that includes a duty to disobey unlawful orders. That's a correct statement of the law. And I don't think that any investigation into those members should ever come up as a result of them making a correct statement of the law. I think that, that concern is real based on this bellicosity that's come out of the White House. And that bellicosity includes the use of the federalized National Guard in our cities.
According to Bloomberg sources, FBI headquarters is pressuring the Bureau's domestic terrorism agents to open a seditious conspiracy investigation into those 6 Democratic lawmakers.
Yeah. I was asked the other day if there is precedent for this or precedent for a military investigation into Senator Mark Kelly. And I said, no, there is not in the United States. There is precedent for it elsewhere. One of the things that the framers of our Constitution, in all their genius, wanted to do was to create a government that was responsible to the people through the legislative branch. And the last time something like this happened wasn't in the United States. It was before the United States was created. It was Oliver Cromwell using his new model army to pressure Parliament to take votes the way that he wanted them to take votes, including the execution of Charles I. We built a constitution to prevent the very thing that apparently the FBI's leadership seems to now think is plausible. Seditious conspiracy, look, to me, if there's a high crime or misdemeanor, it's the attempt to cower members of Congress from exercising their free speech rights. It's not the exercise of those free speech rights themselves.
The Civil War-era seditious conspiracy law requires prosecutors to prove a defendant conspired to use force to oppose U.S. government authority or to prevent, hinder, or delay the execution of any U.S. law. Is it sort of absurd to claim under that statute that this was in any way seditious conspiracy?
Again, I go back to my Alice in Wonderland quote. Yes, in the rule of law, it certainly is that. You can go back to the Civil War, and you can look at members of Congress, slaveholder like Benjamin Gwynn Harris from Maryland, who actually gave a prayer on the floor of Congress for a Southern victory, or a pacifist like Alexander Long, who gave anti-war speeches. And at no time were those two sitting members of Congress investigated or prosecuted. You know, every time you and I speak about the administration, I say they push the envelope. But on this particular case, this truly is, it's beyond absurd. It's truly an affront to the Constitution, the separation of powers, and the ability of members of Congress to represent their constituents on the very fundamental positions that a majority of their constituents elected them to do. Again, it goes back to the pre-revolutionary days, the mentality of Cromwell and the rule of the major generals and the dictatorship of the mid-1600s in Britain, the very thing we had a revolution against.
You know your history, Josh. That's certain. Thanks for joining me. That's Professor Joshua Kastenberg of the University of New Mexico Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.